Good morning. This is Chair French, and I'm convening the regular business meeting for the Kansas Corporation Commission on Thursday, April 8th, 2021. I'm joined by my colleagues, Commissioner Dwight Keene and Commissioner Susan Duffy. On today's business meeting agenda, we have 15 consent agenda items and 5 noticed items. We will begin with our consent agenda. Commissioners, you've had the opportunity to review all of the proposed items on the consent agenda. At this time, I'll ask whether you have any questions, starting with Commissioner Keene.
None for me, thank you.
Commissioner Duffy, do you have any questions?
I do not, and I move approval of the consent agenda.
Second.
We have a motion and a second to approve the consent agenda. Is there any further discussion of that motion? Hearing none, those in favor, please vote aye.
Aye.
Aye. The consent agenda is approved. We now move to our noticed items. And our first noticed item today is in docket number 21, EKME 088 GIE. And it is a proposed order on staff's third motion for a modified procedural schedule. Our presenter for this item is Mr. Brian Fedotny. Brian?
Yes, good morning, Commissioners.
Morning.
On March 29th, staff filed its third motion for modification of the procedural schedule, seeking to extend the remaining filing deadlines by roughly 2 weeks and to reschedule the May 12th workshop to May 25th. The request is based on staff having to devote substantial time and attention to investigating the effects of the extreme weather event on Kansas utilities and their ratepayers. The motion is unopposed. Pursuant to KAR 82-1-217B, the Commission grants staff's motion with one modification. Rather than reschedule the workshop for May 25th, the fourth and final workshop will be scheduled for May 24th, beginning at 10 a.m. And due to the pandemic, the workshop will be conducted virtually. With that, I'm available for questions on that order.
Thank you, Brian. I'll turn to my fellow commissioners for questions, starting with Commissioner Duffy. Do you have any questions?
I do not. Thank you.
Commissioner Keene?
None from me either. I would move approval of the order.
And I second the motion.
We have a motion and a second to approve the described order. Is there any discussion on that motion? Hearing no discussion, those in favor, please vote aye.
Aye.
Aye. The order is approved. Now we move to our second noticed item. This is in docket number 18 WSEE 328 RTS, and it is a proposed order on petitions for reconsideration. And again, our presenter will be Mr. Brian Fedotny.
Yes, thank you. On February 25th, the Commission issued an order rejecting Evergy's proposed grid access charge and monthly minimum bill proposal. That order also denied the Solar Group's request to refund demand charges collected under the RSDG rate. On March 12th, a coalition of electric companies, including Evergy, filed a petition for reconsideration and clarification, seeking clarification that it's acceptable to propose different rates for different services as well as additional services, and that those services are not limited to export service. Also, whether incremental costs are the only acceptable method to support rates on different or additional services. Also on March 12th, the Solar Group filed a petition for reconsideration, arguing that refunds are not discretionary and are required under the law, and that preserving the separate RSDG classification inadvertently denies DG customers from participating in optimal alternative rate offerings. Turning first to the electric company's petition for clarification, on their first point, the Commission interprets the Supreme Court's opinion as finding residential distributed generation customers do not receive a different basic service from standard residential customers. Both standard residential and residential DG customers receive electricity, despite the evidence of some unique usage characteristics. In that limited context, it appears to the commission only an added service such as exporting will justify an added fee for only distributed generation customers, like a proposed grid access charge. The commission emphasizes the limited nature of this finding, which only applies to residential DG customers. Other services beyond exporting may support added fees to residential DG customers. On the second point, the term incremental cost was never intended to be synonymous with marginal costs. Instead, the commission meant the additional costs of providing a different service coupled with the existing fixed costs reasonably and appropriately assigned to that additional service would be a proper methodology for supporting rates on different or additional services. The usual cost of service principles used to allocate costs, common, joint, and direct, associated with providing the additional service will still apply. In other words, only the embedded costs assigned to the export service should be charged to DG customers in addition to the embedded costs assigned to the customer, demand, and energy components charged to both classes. Turning to the solar group's petition for reconsideration, on the question of refunds, the solar group offered legal analysis and arguments in support of its position that they're entitled to refunds. In contrast, Evergy offered no legal analysis or support. Therefore, upon further review, the commission is persuaded that DG customers are entitled to refunds and grants reconsideration on that issue. While the commission generally favors symmetry in refunds, due to the voluntary nature of the RSDG rate, and where some customers elected to be grandfathered and only a de minimis number of customers benefited from the RSDG rate, the commission directs Evergy to refund the difference in revenue collected under the RSDG rate and standard residential rate. And regarding whether preserving the separate RSDG classification inadvertently denies DG customers from the opportunity to participate in alternative rate offerings, the commission finds Evergy's pledge to make the necessary changes to its tariff to make the optional rates other than time of use available to RSDG customers is an acceptable resolution that will result in just and reasonable rates. With that, I'm available for questions.
Thank you, Brian. Let me turn to my fellow commissioners to see if they have any questions for you. Commissioner Duffy, do you have any questions?
I thank you, Mr. Chairman. I believe the order speaks for itself, but again, as was stated in our original order, I do hope parties take this time to look at more modern ways to grapple with this issue. And I note that in California, where there is an extremely, much higher rate of use of solar generation on rooftops, they're dealing with this too and ask parties to submit solutions, and they're studying those. And I am following that and hope that a state like California can perhaps, and the work they're doing, help us here in Kansas. So again, for the parties to be looking at ways to long-term resolve this issue. But thank you very much, Mr. Chairman.
Any questions, Commissioner Keen?
No questions. One very brief comment. I agree with Commissioner Duffy. The order does speak for itself. There are several nuances that are addressed within the purview of the order that I don't think really require much clarification beyond this point. I would just simply note this, that I think within the four corners of the order, the clarification and distinction that's being made here between incremental costs and marginal costs within the context of additional services is somewhat critical. And again, I just offer that as a general observation. The order does speak for itself. I think it provides with reasonable specificity the rationale behind what we're deciding, as well as what it is that we are deciding here. Thank you.
Thank you. Do we have a motion to approve the order?
So moved.
I second the motion.
We have a motion and a second to approve the proposed order described by Mr. Fidotin. Is there any further discussion on that? Maybe I would offer one piece of discussion, just adding on to the comment raised by Commissioner Duffy. I agree we should look at maybe perhaps new ways to address this. I know other states have done value of solar studies, and I don't think doing that study presupposes any particular outcome, because the value of solar can be very different for different areas of the country. I don't know what it would say in Kansas, but I'd like to see us take maybe a more holistic approach, a more modern approach, like other jurisdictions have done, to try to look at this maybe from a different angle. So the order speaks for itself, but hopefully the commissioners have have made their thoughts clear on this. So with that, those in favor, we do have a motion and a second. Those in favor of approving the item, please vote aye.
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 Aye. The order is approved. Thank you, Brian.
Thank you.
We now move to our third noticed item. This is in docket number 21 SEPE 047 TAR, and it is a proposed order on unanimous settlement agreement. And our presenter for this item is Mr. Phoenix Anschutz. Phoenix.
Good morning.
Morning.
On July 28th, 2020, Southern Pioneer Electric Company and Sunflower Electric Power Corporation filed a joint application seeking approval to update Southern Pioneer's 34.5 kV loss factor found in Southern Pioneer's local access delivery service tariff. Joint applicants in their application sort of go into a lengthy explanation of Southern Pioneer's 34.5 sub-transmission facilities. For purposes of brevity, I won't go into it here, but it's in the order for those who would like to see. Throughout the docket, or throughout the process of the docket, several interveners joined the docket, including KEPCO, KMEA, KPP, and KPP, I should say. On January 25th, joint applicants, staff, KEPCO, KPP, and KMEA convened for a virtual settlement conference in an effort to reach an agreement on the outstanding issues in the docket. As a result of that conference, the parties were able to reach an agreement on all issues. On February 2nd, 2021, staff, KEPCO, KMEA, and KPP and joint applicants filed a joint motion for approval of unanimous settlement agreement. This order contains the terms of that settlement agreement and also finds that the settlement agreement is supported by substantial evidence on the record as a whole and establishes just and reasonable rates. With that, I would move approval of the order, and I will stand for any questions.
All right. Thank you, Phoenix. Let me turn to my fellow commissioners. Commissioner Duffy, do you have any questions?
I do not. Thank you.
Commissioner Keen.
None for me either. I'd move approval of the order.
And I second Commissioner Keen's motion.
We have a motion and a second to approve the described order. Is there any discussion of that motion? Hearing none, those in favor of approving in favor of the motion, please vote aye.
Aye.
Aye. The motion passes. The order is approved. Thank you, Phoenix. We now move to our next noticed item. This is in docket number 20 EKME 397 COM, and this is a proposed order in this docket. And our presenter for this item is Ms. Lauren Loshman. Lauren?
Morning, Commissioners.
Morning.
Mr. Flores filed a formal complaint after Evergy trimmed his trees, generally challenging Evergy's vegetation management practices. One of Mr. Flores' assertions is that Evergy should provide him a copy of its transmission vegetation management program. Evergy designated the program as confidential and submitted a copy to technical staff. Mr. Flores challenges the confidential designation. The order provides that Evergy did not satisfy the requirements in KAR 82.1-221A and that the program is not confidential. The order requires Evergy to disclose the program to Mr. Flores without a confidential designation. The order denies the remaining allegations in Mr. Flores' complaint and further resolves all filings in the docket. With that, I would recommend approval of the order and will stand for questions.
Thank you, Lauren. Any questions, starting with Commissioner Keen,
None for me, thank you.
Commissioner Duffy?
I have none. Thank you.
Do I have a motion to approve the order?
I so move.
Second,
We have a motion and a second to approve the order in the 20 EKME 397 COM docket. Is there any further discussion on that motion? Hearing none, those in favor, please vote aye.
Aye.
Aye. The order is approved. Thank you, Lauren. We now move to our last noticed item. This is in docket number 21 EKCE 318 TAR. And this is a proposed order approving limited large customer economic development discount rider tariffs. And our presenter for this item is Mr. Michael Neely. Michael?
Good morning, Commissioners.
Morning.
Last year, Kansas passed legislation allowing electric public utilities in the state to implement economic development tariffs, and they provide discounts for industrial and commercial customers that are not in the business of providing goods and services directly to the general public. On February 22nd, 2021, Evergy filed proposed tariffs to implement the legislation and to offer the discounts. Staff filed a report indicating that the tariffs complied with the statutory requirements that were enacted, but they asked for a minor tweak to the definition section of the tariff. Staff also recommended compliance filings in order to develop annual reports that go to the legislature that are required under the tariff or under the statute. CURB responded and made a filing in the docket explaining that because the discounts provided for economic development are subsidized by the residential and small commercial constituents that they represent, the ability to review the information and conduct discovery surrounding the discounts is extremely important to them. Both of these parties recommended approval of the tariffs, and Evergy did not file responsive pleading. The order before you approves Evergy's schedules and requires a revision to the definitions section within 30 days. The order also requires Evergy to make compliance filings whenever customers are given the discounts or there are changes made to a particular customer's discount. Finally, the order does give Evergy the ability to protect customer-specific information when they need to, because the discounts are largely based on expansionary plans for individual customers, which could be competitively sensitive. However, parties with NDAs on file in the docket will be able to access that information. With that, I would recommend approval of the order, and I would stand for questions.
Thank you, Mr. Neely. Do my fellow commissioners have any questions, starting with Commissioner Duffy
I do not. Thank you, Mr. Chairman.
and Commissioner Keen?
no questions. I would move approval of the order.
And I second the order or the motion.
We have a motion and a second to approve the described order. Is there any further discussion? I would offer just one statement. I'm happy to see this report and this order going out to follow the policy enacted by the legislature. I think it's important to recognize that the goal of this program is not just to stimulate economic development as an end unto itself. It is to stimulate economic development that can increase the customer base of the electric utility, thereby in turn, hopefully reducing energy charges for all customers. It is yet to be seen whether that will be successful. And to that end, I'm glad to see that there are reporting requirements to both us and to the Kansas legislature so we can evaluate how successful Evergy has been over the coming years in growing their customer base. I genuinely hope that they are successful, because this does have the potential to reduce costs for everyone. If you can increase your units of sale, you can spread your costs over those larger units of sale. So I'm very hopeful to see this work, but think it was wise for the legislature to add some reporting requirements so that we can see how it's going and perhaps change the approach in the future if necessary. So that would be my comment. With that, if there's no further discussion, those in favor of approving the described order, please vote aye.
Aye.
Aye, the order is approved.
Mr. Chairman,
Commissioner Duffy?
if I could, or we're pretty much at the end of our agenda, is that correct?
Yes.
Mr. Chairman, do you know, are you that you could be a safe dig hero? Did you know that?
I didn't know that.
It's really simple, but this is our Safe Dig Month, the month of April. And I was so excited to see that Kansas Gas Service is offering the potential to win $100 if you go out and take their Dig Safe quiz. And it's out there for everybody to take at the Kansas Gas Service website. But this is Dig Safe Month, and it is so important to realize they don't bury those lines 6 feet under. They're buried 18 to 24 inches. And it's so easy if, you're out there planting that tree or I don't know, the tulip bulbs. I'm not sure how deep, but just that, hey, it's just me and a shovel. Just make that phone call. And does anybody know that number?
Call 811, y'all.
Call 811. That's right. Good for you. And so to remind folks how important it is to make that call, it's free, but also go take that Dig Safe quiz and see if you're eligible to win that $100. I plan to do it. If I get that $100, guess what? I've got a favorite charity I'm giving it to. I won't tell you who, but it has to do
I've
with.
got an idea.
All right. Thank you, Mr. Chairman.
Thank you. At this,
Chairman,
Commissioner
if I
King, go ahead.
We're going to take care of some miscellany here. On a less lighter note, I had a note to myself that after the fact of our voting on the consent agenda, I found, well, with my apologies to both of my commissioners here, with respect to consent agenda item number 6, involving a penalty order for Clark Energy LLC, it was my intention to recuse. So if we can have the record reflect that recusal, I would be grateful.
Okay. Lynn, I know you're on. Do we need to re-vote with a recusal, or can we go ahead and just note that in the
We
minutes?
can note that.
Very good. All right.
Thank you.
Thank you. That does bring us to the end of the noticed agenda. However, at this time, I move the commission enter into an executive session not to exceed 30 minutes to discuss personnel matters of non-elected personnel pursuant to KSA 75-4319B1 to protect the privacy of the individuals involved. And I further move that the following individuals be included in that meeting, the 3 commissioners and Executive Director Lynn Retz and our Human Resources Director Dennis Pierenboom. Do I have a second?
Second.
All right, we have a motion and a second to enter executive session. Those in favor, please vote aye.
Aye.
Aye. We will now move into executive session, and I'm looking to our IT folks to tell us whether looks like we do have a breakout room to join. So. All right, we have returned from executive session where no action was taken. With that, I believe we can entertain a motion to adjourn the meeting.
So
And Commissioner Duffy, you're on mute.
I second Commissioner King's motion.
All right, we have a motion and a second to adjourn. Those in favor, please vote aye.
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 uh,
Thank you, everyone.
We're adjourned. Thank you.
All right.